that seen from a policy perspective of a home affairs politician and of somebody who is dealing with security issues, I think that political leaders have made the mistake of putting the security institutions in a situation, you need to fix the situation, you need to fix security, but on the other side, not giving a direction where you should go, and not giving also the introduction that this has to be in line with fundamental rights, rule of law, and proportionality. And saying clearly that there's always a way to achieve proper security and proper investigatory power and rule and enforcement of law, while fully respecting these fundamental values of rule of law-based democracies. And there I have to say that in this situation where political leaders made that mistake, we can see that on the other side, the political debate and the public, and we as politicians, representatives of these public debates, would never accept in a society that enforcement capacities are far more limited than the capacities which the society or which business, for example, has to process personal data to survey on their side. There will always be the situation that if information is available, information flow is there, and information is gathered on persons, that these informations by the majority of citizens out there who want to have security needs to be accessed by law enforcement authorities, needs to be accessed by intelligence services. And I say that although, as I said, I would fully recommend them to only do it on the basis of proportionality and on the basis of full respect to human and fundamental rights. So we have a dilemma on the table. And therefore, I say the division of saying we only need to limit the possibilities of law enforcement authorities or of intelligence services to access information, but on the other side say that we need to endeavor the possibilities of big data on personal data, this division is not possible. And we need to accept that. And I think that this is important for this debate which we are taking here, because if you follow me on that road, that this division is not possible, we need to work on something, on a framework in society, on a legal and policy framework, which is incorporating the risk of exposure and the risk of unproportionate access to personal data, and we need to bring in standards horizontally in the processing of personal data, in the surveillance of humans, which are then valid for every processing activities, no matter if it's public or private, if it's law enforcement, or if it's private persons doing this processing. Of course, all of this is in the environment also of other fundamental rights being taken into account, and I think it's very important to repeat that it's no real contradiction that there are different fundamental rights out there. It's not that every fundamental right is contradicting another fundamental right, and therefore I completely reject the image of freedom of expression, for example, or freedom of information is in contradiction to privacy and data protection. It is not. It is two sides of the same medal, and it's both parts of a society which is democratic and based on human rights. What I would like to propose, and that I also end with already because we wanted to limit ourselves, is that we see at the digital world in a way how we saw on the last century of the analog world, which seen from a green perspective mainly involves the protection of the environment during the industrial growth age. And seen from that perspective, you can say that we implemented, and more or less we came there quite a long way, we implemented environment protection as a protection from risk of exposure And we implemented the principle of sustainability in a way that it has to be systematically into policy, into economical, into business solutions, into economics, that this principle needs to be there everywhere. And I would propose that the new kind of environment protection we bring in, the protection from the risk of exposure, needs to be the protection of anonymity. Because anonymity at the end, when we talk about big data and talk about data processing and data collection out there, is the one which is in danger and which we need to protect. And to make it very concrete, perhaps we need to think about regions, not only of environment protection, of nature protection, nature reserves, but we need to think about anonymity reserves. We need to think about where do we implement solutions to protect us from the risk of exposure to lose anonymity in our society. And I would propose to get a new principle besides the sustainability principle into the debate, which is more far-going than only talking about privacy, the principle of self-determination. And I think that this needs to be incorporated systematically in our solutions, in policy solutions, in economically solutions, in business solutions. Self-determination of individuals need to be preserved. We need to get it into our solutions, and this needs to be respected in policy solutions. And that exactly is what we try to do by setting up the new rules for the European market. And I can only tell that being one of those who work on this new revolution of the single law for the European market, we have to say this can only be the start of what we need to do to implement these principles and to implement these protection principles into our digital environment, because it has to be globally, and we need to take into account that there's quite a long way to go, and our proposal for the data protection regulation is one proposal, and we are happy to have the European Court of Justice in our back to back us that these are values which we cannot differ from as Europeans, but we need to bring it into the debates of a global community. Thank you very much.
Thank you, Jan. Paul Nemitz is Director, Fundamental Rights and Union Citizenship, Directorate General Justice of the European Commission. An experienced litigator, he is Chief EU Negotiator in the EU-US Safe Harbour Agreement. After the Snowden disclosures, he was EU co-chair of the EU-US Ad Hoc Working Group on Data Protection, which worked to establish the law and the facts of NSA mass surveillance. Please welcome Paul Nemitz.
Thank you very much, Chairman. I would like to first explicitly thank David Medine for accepting to be with us on the panel today. I think it's a really hard setting for an American to have a moderator from The Guardian, then Jan Albrecht and me. So David, thank you very much. But this is important that you are here today, because the first step in getting rid of this liability on transatlantic relations is to talk about these things openly. We must get out of the hush-hush which some in the security world would like to keep this debate in. And so really, David, thank you very much for being here and accepting this harsh panel. And we have agreed that you speak last to be able to respond to the avalanche of points made afterwards. So I hope very much this is yet another step in bringing the debate on the right balance between security, democracy and freedoms, but also economic growth, creativity in our societies out into the open. And I would like to see more Americans participating in this debate, also here with us, more transatlantic debate on this, because there is not just one America on this. There's a great American debate inside America on how to get the balance right. And I would like to hear more Americans speaking out when a high representative of the security establishment ridicules the quest for proportionality in the form of limitations on collection, but also limitation on use of data, by saying we are being forced to go forward with immaculate collection. What was meant with this joke? And I'm sure many in the security establishment jovially joined in the laugh. Immaculate collection, it was the criticism of those who say the work also of security services have to be subject to proportionality and necessity tests. Mass collection and targeted spying, both, must have limitations. It cannot be that everything what is technically possible is done. That's not democratic. That's not the tradition of enlightenment. That's not how the rule of law works. And so, yes, we want collection which respects, which keeps immaculate the fundamental rights which are universal and which are enshrined in catalogs of fundamental rights on both sides of the Atlantic. And yes, we in Europe believe indeed that we in Europe have, for historic reason, a lead in protecting privacy and data in the markets and also in the public sector. But we need America to take the lead on getting proportionality right when it comes to the use of national security tools. America must take the lead in doing this. Why? Because America has enormous resources which are unmatched by any other power in the world in this area, and these resources are the combination of state resources, NSA and 16 other agencies, with the private resources from companies like Google, Facebook, and so on, which at least in Europe often have dominant positions. No European can use the internet without using these services. And whoever uses these services will be subject to collection, mass collection, indiscriminate mass collection by United States services, because every signal which is sent through the transatlantic cable to the US is sifted through one way or the other. This was described to me in the working group where just reference was made, like the search for gold. Don't worry, Paul. It's like the search for gold is no big deal. You just take a sift and you hold it into the water and you hope the gold sticks in it. That's what's happening to our data when it goes through the transatlantic cable. And well, here we have a basic divide between the US and Europe in the sense that for Europeans, this initial acquisition, this sifting through is already the first ingerence into the fundamental right. So yes, we need collection limitations and use limitations, not only use limitations. Let me say that I find that the discussions we already had between Europe and the United States actually quite fruitful, because in Brussels we felt, and Vice President Reding said it at the time, that the speech of the President of the United States of 17th of January and the Policy Directive number 28, which contained a work program for the security community in the United States to get things straight, to introduce proportionality and necessity tests, was a good start. But since then, we are waiting for delivery of protections which are effective for Europeans. And that's what we have always insisted on, and we will continue insisting on. You have just heard it again in the hearings of the new Commission in the European Parliament. the suspension of the safe harbor is an option which is on the table. And the key to maintain the safe harbor is to get proportional and necessity limitations on the use of the national security clause. It is inconceivable that on this point